Hello, and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, are you or someone close to you thinking of moving their family from California to Texas? You wouldn't be alone, I got to tell you that. And as you would expect, there is more to relocating than just packing and unpacking. And due to its financial and personal significance, estate planning should be high up on the to-do list. So what's our topic today? It's the 3 questions California residents should ask about their estate plan before relocating to Texas. Thank you for taking time to check us out. And if you enjoy this episode of the 3 Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. High net worth Californians are increasingly relocating to Texas, and they're drawn by the state's lack of state income tax, along with lower costs of living and average housing costs somewhere between 30 and 50% less in California. And specifically, we'll talk about San Francisco and Los Angeles. And then you have Texas' business-friendly environment, more affordable luxury lifestyles. They further appeal to those seeking to preserve and grow their wealth without California's regulatory burdens or high estate tax considerations. Now, all of this means careful estate planning is essential to navigate the differences in laws between the two states. And we're going to address that today as we explore the 3 questions California residents should ask about their estate plan before relocating to Texas. Joining us from Brenham, Texas, is Marlyn Shulz. She is a Texas estate planning attorney who is also licensed in California. And with her firm, Brenham Estate Plans, Marlyn specializes in helping clients navigate complex relocations, estate strategies, asset protection, and drawing on her dual estate experience as an attorney to ensure that there's a seamless transition for high net worth families when they're making that relocation. So, Marlyn, great to see you again. And thank you for making time for the podcast today.
Thank you so much for having me, Wayne. I'm excited to be here today.
Yeah, I'm really glad you're able to make it. And we got a lot to cover today. And, I want to continue this conversation about the conversations you're having with clients that are making that relocation from California to Texas. Are you finding any trends as to their motivation for relocating? Now, is it the lack of state income tax in Texas? Is it the overall lower cost of living? Is it business-friendly environment, a booming job market? Or is it because they just it's a more affordable lifestyle? Like, is there anything that people have come to you and said, well, we're moving here because this is the reasons why? Have you seen any trends whatsoever?
Everything that you've just said is the answer. A lot of my clients, even if they're middle income or high net worth, it really doesn't matter. What they're really looking for is to see that dollar go further. And Texas has a really high standard of living for a much lower cost than you would find in California. And it has a very, very business friendly environment. I would say, in some instances, actually creates sort of an incubator for new businesses because of its tax code. And so, again, that more affordable luxury lifestyle coupled with a great business environment and a booming job market, they all sort of coalesce to make Texas one of the best places to relocate if you're looking to move from California.
So kind of check, 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 and check, more or less, right? Okay.
Absolutely.
Okay, I will tell you right now. So when this all sort of evolved, and I think about COVID was kind of where this started to percolate.
Yes.
So I will admit that I wondered how long it would take some of these families who made this move would turn around and move back to California. And I'd point to the fact that, we all know Texas has higher property taxes, right? As an example.
That's right.
Then you have to acknowledge there is definitely, for someone from California or who's used to living in California, there's some cultural adjustments,
That's right.
for sure. And then there would be this yearning for California's Mediterranean climate. And don't I want to remember also the gorgeous topography that we have here. So what's interesting, even with all that said, we have a net migration of around 100,000 Californians annually in this year in 2025. So, your thoughts on that?
Honestly, we have some of the best job market possibilities for incomers from California. So whether that's you're in the tech industry, we've seen Elon Musk move a gigafactory here. We've seen Oracle move here to Austin.
Joe Rogan
Health-
moved to Austin.
exactly, exactly. There's a lot of burgeoning
Podcaster, no
industry.
doubt.
He's your competition, Wayne.
Yeah, yeah, right.
But essentially, what we have is, I think, a really great job market for a variety of industries. The oil and gas industry has always been strong in Texas. I don't think that's going anywhere anytime soon. There are a lot of ancillary industries that have sort of built themselves up around the oil and gas industry, and they are continuing to hire. We are always going to need oil and gas in our everyday lives. The healthcare industry in Houston is certainly popping up as well. And again, just because of that lower cost of living, you're getting paid a great living wage. You can afford to live here. It's not like it is in California where you get a living wage, you may not be able to afford to live there anyway. So that's, I think, really the difference.
Well, last week I was in Dallas for a
Mhm.
few days for several reasons, including having to pay off a hockey bet to my good friend Mark Nielsen, who I'm sure is listening, since he moved from California to Texas. So I'm sure Mark and maybe even his wife is listening, Maria is listening as well. So as usual, and
Mhm.
this is inevitable,
Right.
when I go to Texas, I get the inevitable question, when, not if, when are you moving to Texas, Wayne? So for now, I am sticking to my guns and staying here in California for now.
Knock.
I will not use that word never. Let's just put
Mhm.
it that way. So we'll see. I'm sure you have a more than your few a share of friends that have made the move as well. So maybe
Absolutely.
even some skeptics as well.
Absolutely. And I was actually one of them at one point in time. So I myself relocated from the San Francisco Bay Area, and it was literally because the cost of starting a law firm in the Bay Area and what that retirement looked like versus the cost and retirement here in Texas were just very different pictures. And frankly, I mean, there are just some advantages to doing it here versus in Texas. Again, there's, in terms of being able to, pay yourself a good wage and actually having that dollar go somewhere. I can't say enough about that, but also the tax environment, the lack of taxes here. And again, that small business incubator, we really do really well in terms of that. But you really have to want to stay in California. You really have to want to pay those things. And I just don't see that being a value add in terms of being a small business owner such as myself.
Yes, I keep hearing this, and all you have to is look at your tax return every year to figure out what you're paying the state of California for the pleasure of living here. I'm more than aware of it.
Yes, yes. And imagine what that money could go towards if it wasn't
Yes,
going
I
to the
know.
state.
I keep hearing, and this isn't just coming from my friends in Texas. This is also coming from my friends in Florida as well. So I get it. Whether I go to Texas or I go to Florida, when are you moving here, Wayne? Well, we'll see.
There's great property here in Washington County. I know a few realtors. We can set you up. You can have a ranch. You could be my
Yeah,
neighbor.
yeah. Well, and I have a client in Naples that keeps reminding me of the same thing. No ranches though, and they swear the water table isn't going to rise too high. So, okay. So today we're discussing the three questions California residents should ask about their estate plan before relocating to Texas. Now, our questions are from the perspective of a California-based family looking to relocate to Texas. So not from mine. We're not asking them. Marlyn's not asking them. They're getting the questions of taking their questions and answering them. So, Marlyn, are we ready to go?
Let's do it.
Okay. Question number one. We are in the process of relocating from Northern California to Austin, Texas, and want to be sure that we have all of our affairs in order. Do we have to change our California estate planning documents? Marlyn, away
You,
you go.
you better. You
You
absolutely have to.
better. You better.
So the two bodies of law, although, Texas and California are both community property states, and there is a lot of congruity between how they treat property at death and divorce. The reality is the state coding systems are very different. And what you want to do is make sure that you are in conformity with Texas law throughout the scope of documents. If you are a California resident moving here, that means that most likely you have a revocable living trust. There's very specific language that needs to appear in that trust for you to take full advantage of the Texas tax code, and it's not going to be in your California trust. And likewise, you'll have other documents that are, built around a California code system, laws that are not applicable here in Texas that can really create some problems during death and during incapacity.
Well, if changes are needed, this is something else I was thinking about the specific elements, and I'm thinking of, powers of attorney, uh, and also should that be updated, or can they remain so that you're not changing powers of attorney, but do they have to be somehow repapered if when you move to Texas?
Absolutely. So Texas has some very specific laws regarding your healthcare decisions, regarding your property management decisions. Very specifically, the Texas Durable Power of Attorney has language in there, should have language in there that says who can operate your business. So if you're a small business owner, you've got a family-run shop, you probably have done zero business succession planning. If that language doesn't appear in your Durable Power of Attorney, the agent under that document cannot help operate your business if you become incapacitated. And that can be a really tragic event in terms of revenue generation. So you really want to make sure that that document is upgraded to Texas law, especially, and also your Texas revocable living trust. It should have language in there that talks about your primary residence, your homestead of residence being a qualifying trust. If there is not language specific to the Texas tax and property code inherent in that trust, you're going to lose your homestead exemption. So again, you want to make sure that your documents are upgraded to Texas law so that you can hang on to all of those important protections.
Something else I just thought of, in California, and I subscribe to this as well. So a lot of families will use a independent fiduciary to take
Mhm.
on the role of successor trustee and also power of attorneys. I fall into that category. So for folks that move to Texas, now I know we talked about this actually. Actually, we were on a Zoom call yesterday morning talking about this
That's right, we were.
particular. So what is the how often, I guess is be the best way I'll put it to you, that will people use a third party fiduciary to take on that role because either they don't have, I think about, with all the Canadians I work with, people moving from Canada, they move to Texas, they don't know anybody, or they
Right.
don't have lifelong, living like, established friendships or whatever. So the idea of using a third party fiduciary to be their successor trustee and or power of attorney, is it as common in Texas as it is in California?
So, so let me back up a minute and sort of talk about why trusts are more common in California than they are in Texas, and then we'll talk about why that industry is burgeoning, but it's not
Okay.
quite at the level of where it is in Texas. So, in California, the probate system there usually takes about 12 to 18 months. There's a statutory fee that is unavoidable. And so a lot of people have revocable living trusts specifically to avoid that kind of environment. Texas probate system is not quite as expensive. It doesn't take as long. And so we really don't have a whole lot of trust work being done in Texas, or at least not historically. That is changing. Presently, that is changing. And so the concept of a private professional fiduciary usually comes up when we start talking about multi-million dollar estates, complex estates, or when you have family members who really don't have good financial acumen or really just don't want to handle the stress of managing trusts during periods of incapacity or when somebody passes away. And so, in those instances, what I counsel my clients on doing, I usually say if you have an existing relationship with a bank and they're managing your funds for you, they typically have a trust department. They'll usually charge about 1 or 2% of the assets under management so that they can manage the transition during periods of incapacity or during death. And that's a pretty good way to go. We do have a few private professional fiduciaries in Texas that will handle that work. They're typically attorneys. So it would mean finding an attorney who was willing to take that on as a role, but it's not impossible to do.
Yes, and I can vouch for the latter. Being an independent financial advisor, the likelihood of us encouraging our clients to retaining a bank isn't very high.
No,
Uh,
probably not.
yeah, that would be counterproductive.
Mhm.
So yeah, that's exactly. We have a case. I can tell you right now. I'm glad we discussed this. Yeah, I was able for clients of mine in Austin. I was able to find them an attorney that would act in that role.
Oh,
So
good.
there are options, and my guess is that we'll be using that option more down the road as well. And again, if you're, and again, in that particular case, there was a special needs child that needed to be taken into consideration. There was a lot of moving parts there, and newly located from Canada to Texas, didn't really have any established friendships and
Right.
that
And
type of deep.
you don't want to, work with a Canadian citizen on a US trust. Again, it's going to have very negative tax consequences.
Yes.
It really is better to find a private professional fiduciary to manage things like that. So I agree. You've definitely gone the right route for your client.
So our topic today is the 3 questions California residents should ask about their estate plan before relocating to Texas. And again, Marlyn Shulz is my guest today. She is a Texas estate planning attorney, and she is also licensed in California, and she specializes in helping clients navigate very complex relocations, estate strategies, asset protection, and more. Marlyn, great to see you, and thank you for being here. Let's go on to question number 2.
Sure.
My husband and I have been discussing the possibility of relocating our family from Southern California to Dallas, Texas. One of the red flags that we've been made aware of is property taxes in Texas. Are they really that bad?
I wish I had a better answer for your client, but the unfortunate answer is yes. They really are that bad. You can describe the California property tax environment much like you would a crock pot where you just sort of set it and forget it. You get maybe a 1 or 2% increase year over year. And you really don't have to worry about shocks unless there is a change of hands in terms of that titling. So once the title transfers, that's really when you're going to see a reassessment to fair market value. In Texas, we do fair market value reassessments year over year. And so that means that you can find a pretty hefty tax bill waiting for you come November. And if you're not prepared for that, that can be quite a shock. And so I do counsel my California transplant clients be on the lookout for this. There are tools in the tool shed that we can use to ratchet that number down, but we really need to be aggressive in terms of how we use them. So yes, it really is that bad.
Okay, so that was actually going to you great minds think alike here. That was exactly what was going to be my question, though. I mean, are these like in a black box here, Marlyn? What are these? What are the strategies here? I'm sure there are folks that would be eager to know how.
Sure,
How do
sure.
we
So
deal with this?
yeah, so the number one exemption that every Texan has, if you are a homeowner, you have your homestead exemption. And right now in Texas, that means that the first $100,000 of the market value of your house is not considered in terms of the overall assessment of taxes. So if you have a $300,000 house, you're actually only going to be assessed on $200,000 of the value.
Hmm.
And that's really, really important to hang on to. And again, drawing back to, getting those estate planning documents taken care of. Again, if that qualifying homestead language is not in your trust, you are not going to keep that. And you absolutely want to do that. And that can mean the difference between, a few $1,000s to tens of thousands, depending on the value of your property. So you really want to hang on to that. So that's tool number one. It's the most common one that's used. We trot that out quite a bit for our clients. The second one that I'd like to talk about is actually something that's a little bit different. And these are special land valuations. So this typically happens when you have a second property. It's not a homestead property. It's likely acreage, just acreage out in the hinterlands or whatnot. You're going to want to put an ag exemption on that, an agricultural exemption, or a wildlife valuation on that. And basically, what that does, it's not based on the market value like your homestead property would be based on. It's actually based on the land's productive capacity. And
Hmm.
depending on how that is calculated, and obviously there are rules to how to do this, but you can reduce your property tax exposure sometimes up to 80 or 90% just by putting that agricultural exemption on there. So you really want to make sure that you understand how this works and that you do that. Some people, that means that they're leasing that property for cattle. Some people, that means that they're producing hay on that, or they've left it open for wildlife, or they're keeping bees on the property. Any and all of that absolutely qualifies, but you have to be really good about using it, and you have to keep really good records for it. So that's number two. Um, we also have some property tax exemptions for businesses. And so one of those is a 20% cap on smaller investment properties. So if you are a real estate investor, you have a second rental property, or you have a modest commercial building, if that piece of property is worth $5 million or less, then you have a 20% annual cap on that taxable value increase. So again, that's another way to sort of ratchet down, how much that property could actually be taxed to you. And so again, really important to hang on to that. And last but not least, this is really for the Elon Musks of the world, and we hope that they keep coming to Texas and bringing all of their jobs with them. We also have, a technology program in Texas. We call it the Jetty program, and basically what it does is it allows large scale operations to move to Texas, and as long as they're producing, let's say, 75 jobs and over 200 million in infrastructure improvements, then we will reduce their property taxes over the course of a period of 10 years. And so again, what we're trying to do is we're just trying to draw people in, we're trying to draw business and job creators in, and this is how we do it. And those are one of the tools that we'd like to use as well.
I have one for you regarding the rental property question. This
Sure.
is the follow-up. So utilization of LLCs.
Yes.
And does that affect? I don't think it does. I'm probably going to answer my own question here and say no, but what effect does that have on if I have a rental property and I put it into an LLC? Well,
Right.
I'm going to let you explain why that's a good idea. But
Okay.
the second question is, if I do that, is there any different tax treatment of that property than if it's owned in your own individual name?
No. So the good news is that let's assume it's you and your wife who have a second home that you're using for a rental.
Yeah.
And you've decided to put this home into an LLC. The reason why you do that is to maintain a shield from personal liability. So if anything happens on that property, your renters decide to do something horrible and somebody gets injured, or something just happens on the property and somebody gets injured, they can't pierce that business entity and come after you personally. Everything that happens under that LLC dome stays there. So it's really great to make sure that you do that for rental properties, especially. And it doesn't receive any kind of different tax treatment. You still qualify for that 20% cap. Basically, the Internal Revenue Code is going to treat that like it's a disregarded entity anyway, because you and your wife are basically a single entity as far as they're concerned. And in the state of Texas, again, they're still going to garner that kind of tax preservation for you as well. So you don't have to worry about that at all. It's as far as they're concerned, that's a transparency.
So just imagine someone listening to the podcast right now and they're going, "Oh man, I don't have my rental property in an LLC. Is it too late?" In other
No.
words, it's not. It can be even if they have a mortgage on the property. Well, I mean, is it a major deal with going to a bank and saying, I know I'm the owner, my wife and I are the owner of a property. Can we move it to an LLC, even though we've been, banking, have a mortgage that's been in place for say 3, 5 years? Is it?
So that can create some problems. I will be honest with you. Your mortgage company, especially if the interest rate that you have now is lower than the one that they would eventually give you in some sort of commercial arrangement, they may decide to change that on you. They could demand that you refinance. So just be aware of that. But I do want to say
Interesting.
though that you got to be careful. You got to shop around. But when interest rates are low, you should absolutely think about doing it. But honestly, the personal protection that you receive from that, I almost wonder if it's not worth it. Because again, especially if you have, let's say, an Airbnb or something along those lines, Airbnbs are inherently more of a risky prospect because you have person over person over person over person in that
Yeah, it's a
property.
law
And
of
so
large numbers.
that's a law. Yeah, exactly. It's the law of large numbers, and that means that you're increasing your risk in terms of liability every time somebody sets foot on that property, and you don't necessarily know who those people are. And so, really, if you've got an Airbnb situation like that, I would think you kind of want to bite the bullet, especially in terms of not having your own personal assets attacked. If something happens and it punches through the upper limits of your insurance policy, you definitely want to make sure that shield of liability is there.
All right. Well, that's fantastic information, and that's why we have you here, Marlyn.
Happy to
Okay, let's
help.
go on to our final, third question.
Sure.
So question number 3: how do differences in community property laws and homestead exemptions between California and Texas affect my estate plan, and what adjustments must be needed to protect my assets? Okay. We've been talking
Sure.
about this already, so maybe we have to do a bit of a recap here.
No, 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 it's okay. So, Texas and California are both community property states. And so, at a 30,000 foot view, what that means is that presumptively any property that you acquire during the course of marriage is considered part of the community estate. Okay. So that's what we mean when we say community property. And the differences between Texas and California are a little nuanced. This is really more about language driven approaches than anything else. And so, really, what we're talking about is how is the language in your agreement structured to affect the right things happening under community property law. So, in California, what we're looking for in terms of community property titling, we are looking for the language that says community property with rights of survivorship. Okay. On its own, community property is not going to automatically be absorbed by the surviving spouse. That doesn't happen in either state. Okay, so what you have to do is you have to make sure that you have language in there that says in California, this is community property with rights of survivorship. In Texas, what we have is something called a community property survivorship agreement. And this is usually memorialized in your documentation. So in your will or in your trust, you are saying specifically, my property, my half of my community property is going to go to my surviving spouse. Okay, that's the agreement. It has to be in writing and it has to be memorialized as such. Otherwise, if that doesn't happen, this is going to pass to whomever under the residuary clauses or to whomever under the Texas intestacy law if you don't have any documentation.
Ooh, that's not a good thing.
Never a good thing,
Never a
honestly.
good thing.
It's surprising though. I have to say, 60% of Americans, regardless of their financial background, they will die without any kind of estate planning documents. And I think it's just, blind optimism that maybe death isn't going to get them. But the news is that 100% success rate with that.
Yeah, I was going to say to
Um,
my, I had a client
yeah.
come into my office one time and he said, Wayne, I remember this back when I was in Toronto. Comes into my office, I can almost envision it now. And he came in, he says, Wayne, I have not heard of one person walk off this planet alive with their money, and I don't think I'm going to be the first one.
No, no. I mean,
That
again, some people are
began the estate planning strategy conversation.
absolutely. And like I said, some people are just, they're very optimistic. I love that for them. But it's not a good strategy. I can say that definitively. We go to a lot of funerals as estate planners. It happens to us all. Um,
And yeah, I would just also add that if you die intestate, this is an attorney here in California told me this one. He says, here's the news, Wayne. You have an estate plan, even if you don't draft one. It's just that it's made by the state. And
that's
you may
right.
not like the way things unfold and who ends up getting your the residue of your estate if the state of California in this instance gets to pick.
That's absolutely right. And again, just having really solidly drafted documents that reflect not just your family values, but the people that you want to protect or maybe the people that you want to disinherit, all of that should be in there. It should absolutely be in there. You don't want any surprises. And you definitely don't want litigation. That's just the long and the short of it.
Okay, one last more a follow up to that last question.
Sure.
Now, if if an estate in this last case has retirement accounts, IRAs, for example,
Sure.
business interests, how would you recommend that they restructure them during relocation? And the
Sure.
purpose of this would be for tax efficiency, creditor protection under Texas rules. Now, as far as I know, I don't know if anything specifically would be done to an IRA, but potentially for liquid assets. Your thoughts?
Sure. So if we're planning on performing a Roth conversion at any point in time, don't do that until you've settled in Texas, till your domiciliary is in Texas. And the reason again is because we don't have state income tax. So when you start taking those withdrawals out of there, what you don't want to do is start paying state income tax on those withdrawals. So wait until you come here to do that. And in terms of business interests, honestly, and this is kind of what I was driving at in terms of the business incubator. We have great creditor protections for small businesses in Texas. Our tax system for small businesses is really favorable to small business owners. And so if you have a California business, you can domesticate that here in Texas, which means you keep the EIN, you keep the business name, you keep all the contracts. So it's not like you have to start from scratch. So that's always great. But then the other thing is, again, with those creditor protections, that there's a charging order that happens or that's issued by a court when there's a creditor judgment against you personally. And that charging order in Texas says the only time they can go after that business, they can't force you to sell it, but they can take a distribution if and when a distribution from that company comes to you. That's not
Hmm.
the case in California. So in California, a creditor can go after your LLC and force a liquidation to satisfy a personal judgment against you. So Texas has it beat. And then in terms of, again, in terms of, just, business taxation here, unless you're making 2.47, I think it is, in annual revenue, you're not paying franchise tax.
2.47 million.
Yes,
Right.
you're
Okay.
not paying franchise tax. So you're filing a no tax due report, which is great. You're not doing that in California. You're paying. They're going to make you pay. So again, move it here, domesticate it here. You can do that.
Okay. So you have the benefit of being licensed as an attorney in two states, California and Texas.
Hmm.
So, what would you say, and this is based on your experience of dealing with people from both states, what would you say is the most common misconception that Californians have about estate planning during relocation? And how can they sort of avoid or ensure they have, I guess, a smoother transition and sort of alleviating any of these misconceptions they have?
Sure. So the number one misconception that my California clients have is that they no longer need their revocable living trust. That probate in Texas is not that complicated. And to an extent that is true. But the reality is if you dissolve a revocable living trust, all of those assets have to be retitled back into the names of individuals. You've already done all the heavy lifting. There's no need to get rid of it now. The other thing is, Texas probate, it's not super complicated. It's not like it is in California, but it's still expensive and it still takes time. So don't listen to the estate planning attorney who's never done a trust in Texas to say, you don't need this. We're just going to get rid of this and we're going to go back to wills. Don't do it. Just hang on to the revocable living trust. Just restate it to Texas law and hang on to it because honestly, you're going to go through probate if you don't. And probate again is expensive. It is time consuming. Not like California, but still, you're putting your family through this needlessly. You've already spent the money on a revocable living trust. You should just hang on to this. And also, and this is just a horror story that I do need to share. I did have a California client contact me to say that her father had moved from California to Texas, dissolved his trust, and then forgot that there was a 60 or $70,000 Golden One Federal Credit Union account in California that was still in the name of the trust. And so to
Mm.
get that money out, they either had to accept a new certification of trust and accept the story that we don't have a copy of the trust. We don't even know who the successor trustee is, but we would like to relinquish this money. Or we were going to have to petition a court in California to get this money out, which is again, tens of thousands of dollars. And so luckily, we were able to have them accept the new COT and a new successor trustee without having to go through court to do it. But that is a rarity. Most financial institutions will require a court order to relinquish those kinds of funds. So we got very, very lucky that day, but you do not want to take that chance. So once you've done the retitling, keep it. Just hang on to it. You're not gonna want to go through probate anyway. Just hang on to it.
All right. That
Mhm.
is a horror story.
It is. It
And
really
and
is.
and 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 they're lucky there wasn't more. Could you imagine? I mean, 60,000 isn't chicken feed, but
Well,
there's zero on the end of it. I mean, 600,000.
and think about it this way, if it really did take a court order, you're eating up all of the proceeds just trying to get that money
Exactly.
over there.
Thanks for coming. Okay,
Hmm.
so before we wrap up here, I
Sure.
just want sort of to look ahead.
Hmm.
Uh, so we're going to assume that California is going to continue migrating to Texas. Okay, we'll make that assumption.
Sure.
So, are there any sort of emerging trends or estate planning laws, things that people should be thinking about? If they're moving from California, is there anything they should be thinking about that's coming up that they should be aware of?
There is one emerging trend that I do want to speak to, and I want to be really sensitive about how I sort of touch on this topic. And that's basically using as durable powers of attorney as sort of a mitigating tool against detention by law enforcement. I know that that sounds very, very strange, but I want to walk you through what that looks like. So your typical durable power of attorney says who can manage your property during periods of incapacity. And the reason why adding detention by law enforcement is important nowadays is because law enforcement can detain you for a certain period of time, and this is coming up a lot in my Latino business owner communities where they are afraid of being deported. They're afraid of being held by ICE, and honestly, if you don't know how long you're going to be in ICE custody, you don't know how long your detention is going to last. It could last hours, it could last days. And the reality is, if there is nobody running your business, if there is nobody managing your financial affairs, this can have a really serious impact, a very negative impact on the bottom line for your business and also for your family. So I do recommend that for people in those vulnerable communities, just have that durable power of attorney upgraded to state that any amount of time spent in law enforcement custody is a reason for this document to trigger. You definitely don't want your family trying to pick up the pieces in the middle of a crisis. There should be a clear and concise plan as to who is managing what. And it's just better to have a plan to plan before you're panicked, because panic decisions are not ever made well.
And let's be clear here. This does not only apply to folks moving from California to Texas.
No, no,
No, this is people
absolutely.
who live in Texas, right? That you're talking about.
Absolutely. Absolutely.
Yeah. Okay. Well, extra tidbit here. That's excellent. Okay. We got a lot of people watching here on the website, and we've made a note to include your contact information underneath you on the screen there.
Thank
But
you.
we have folks that listen on Apple and Spotify as well. So for those who are listening in, and I know you're not a provocateur, but you said a lot of really interesting things today here, and they may want
Sure.
to say, I need to talk to Marlyn.
Sure.
So what is the best way for them to get a hold of you? How do they contact you?
Sure. The best way to get a hold of me is to call our main office number. And that number is, and I'll slow down, it's 281-529-5176. Again, 281-529-5176. Or you can reach me personally via email. It's my first name, Marlyn, Marlyn, at Brenham Estate Plans, that's plural.com.
Perfect. Okay. Well, listen, Marlyn, this was fun.
It was, Wayne. Thank
This
you for
was
having
good. I
me.
told you we would do this would be good, and exceeded my expectations. So again, Marlyn, thank you very much. Marlyn Shulz is a Texas-based estate planning attorney who is also licensed in California, and she specializes in helping clients navigate complex relocations, estate strategies, and asset protection strategies. So Marlyn, thank you very much.
Thank you so much, Wayne.
I look forward to bringing you the Three Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification of when our latest episode has been posted, please click on the notifications bell. Last but not least, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.